My Lord, I have an objection, my Lord, to that, because the information that the state has just disclosed now, my Lord, it's related to the evidence of the witness who is currently testifying. And that information, my Lord...
To the witness who?
Who is testifying?
Yeah, fine.
Yes, my Lord. That information, we have not been given the opportunity to listen to it. It has just been disclosed to us, my Lord, now during break. Therefore, my reasons for objection, my Lord, is that it is crucial to listen to that portion of evidence before this witness testifies.
But this witness is in the middle of a testimony.
The state decided to disclose a new evidence in the middle of the testimony, my Lord.
No, but if I understand Mr. Baloyi, he says he initially did not intend to use that evidence. Am I quoting you correctly, sir?
Indeed, my Lord. It was just...
Listen when people talk.
For the purpose of being open and transparent in the defense.
And it tells you we've heard this.
My Lord, the state may not be intending to use it, but as a defense, also once it has been mentioned that the evidence is available.
We're entitled to it.
We're entitled at least to listen to it, my Lord, so that we can be able to proper instructions, whether we are on the same page with the state.
No, fine, I don't have a problem with it.
That we won't be using it, because maybe...
We are entitled to it, because in terms of the case of State versus Shabalala, any information which is in the docket of the state, is it except A, B?
Yes.
Hello? Is it sections A and B?
Yes.
The other information should be made available.
Yeah, B and C.
The other way around.
Yes. And this one is part A, my Lord.
My Lord, I have noticed that from yesterday, or since I came on board, particularly yesterday, this discovery was made during the examination of the witness. And the state indicated that it does not intend to use the recordings. But copies were furnished to us, and this morning, to our surprise, and I just want to clarify the point made or the submission made by my colleague to say we all listen to the audio recordings. In the view of the fact that the state was not going to use it, I opted not to use it, and I consulted with the accused in relation to the intentions if the state so intend not to use the same recordings. My Lord, this morning, as the state is approaching us, and the state had an ample time to research the law in relation to their submissions that they are making before this honorable court, and the defense has not been given time. Hence, if that is the submission that the state will stand by it, I would actually submit and request the honorable court to suspend the submission made at the moment for the defense to continue the cross-examination and make proper preparation in response towards the submission made by the state, my Lord.
Such an egregious flouting and flagrant flouting of accused number 2's constitutional rights in terms of section 35(5), it would not be in the interest of justice to do so, because accused number 2 would then be continuously subjected to a trial unfairly, when we know that the Constitution engages us and enjoins us to prevent such an exigency. And also in the view of this court, that would bring the administration of justice into disrepute. Consequently, this court rules that the audio recording should not form part of these proceedings. It is inadmissible.
But you never requested the copies of Mr. Mngomezulu to be the FFC certificate and the appointment certificate. You never requested it to be copies to be made out of them. Is that correct?
That is correct. Kuqiniswa ukuthi kaMngomezulu wona ke amaphepha angizange ngicela ukuthi akwenziwe amakhophi awo.
And Mr. Mngomezulu, that Dominic Mngomezulu, unless if he's called to testify, what he told you cannot be accepted in court as hearsay evidence. You agree?
That's correct.
That is correct. Yebo ke angitshela kona ke uMngomezulu lokho akwazike ukwamukeleka enkantolo nanje ukuthi into engayizwa ngoba ngaphandleni kokuthi abizwe eze yena azofakaza.
And that failure to prove that evidence cannot be corroborated by the copies that should have been attached in the proforma. Do you agree?
Daar is geen kopie aangeheg wat die inskrywing op hierdie bekentenis tot daai effek bevestig nie. Dis korrek.
That is correct, yes. There is no copy made with regards to that which is attached to this confession. Kuyiqiniswa ukuthi ngempela akayikho ke icopy yaloko noma lokho obhaliwe lapho ekhona noma eyingxenye yale statement lesi.
So this honorable court cannot accept the evidence of a discussion between yourself and Mr. Mngomezulu. Do you agree?
In terme van wat?
With regards to what?
The conversation between yourself and Mr. Mngomezulu, who said is the attorney, Dominic Mngomezulu.
Dit is bevestig deur die persoon wat die bekentenis self gemaak het ook en hy het hierdie man uitgewys ook as sy prokureur. En hierdie man het bevestig dat hy die prokureur is. So ten opsigte van die voorsittende beampte myself moet ek aanvaar as 'n persoon 'n bekentenis kom aflê en hy self wys na hierdie man en sê dit is sy prokureur en hierdie man bevestig dit dat dit wel so is.
This was mentioned or was said by the deponent of the confession, and then the person himself confirmed that indeed he was the lawyer. Now I, as the presiding officer, the person who was now taking down the confession, then has to accept that indeed if the person, the deponent says this is his lawyer and he confirms that it is indeed so. Lokhu ke kwakhulunywa uyena ke lona owayezokwenza istatement ukuthi ummeli wakhe. Naye ke lo ekuthiwa ummeli naye ke wase eqinisekisa ke lokho ukuthi ummeli. Nanjenge manje ke mina ke engizokwenza ukuthi ngamukeleke ukuthi lokho abangitshela kona ngempela kukanjalo.
Ek het myself vergewis met die dokumentasie wat hy voorgelê het, met dit wat die persoon wat die bekentenis afgelê het aan my meegedeel het, asook hierdie prokureur. Maar u is reg. As die staat as hy dit in twyfel getrek word dat hierdie persoon sê wie hy is, dat hy nie 'n prokureur is nie, dat hy my as voorsittende beampte mislei het, of dat daar 'n bewering is dat die persoon glad nie eers daar was nie, dan moet die staatsadvokaat toesien dat hierdie persoon geroep word. Wat my betref in daai omstandighede, was ek tevrede dat en oortuig gewees dat hierdie man sê wie hy is en dat die persoon wat die bekentenis aflê wel ook tevrede is met hierdie man wat sê dat dit sy prokureur is en dat dit is die persoon wat hy aangestel het.
This was said to me by the deponent, and then the documentation was then provided or shown to me. I satisfied myself with that which was said by the deponent, as well as the documentation, that it was indeed the case. If now there is this allegation now from your side that this person was not a lawyer, or was not an attorney, or that this person was never there, then indeed, yes, as you say, the state will then, or that this person misled me as the presiding officer, then of course it is incumbent upon the state to then call this person to come before the court.
Thank you. So, to your knowledge, you are not sure if, okay, let me just put it this way. Let's get into, I'll just sum up my questions in relation to Mr. Mngomezulu by saying, other than a confirmation by the interpreter, there's nothing that you can confirm that Mr. Mngomezulu was present on that particular day.
Die kliënt kan dit bevestig.
Your client can confirm that. Njengoba uthi ke ngaphandle kotolika akukho kunye okungaqinisekisaka ukuthi uMngomezulu wayekhona, lona ommeleke angakuqinisekisa.
It's my instruction that he was not represented on that day, and he does not even know Mr. Mngomezulu. It's my instruction. That's why I'm still insisting on the right to legal representation.
As dit u instruksie is, dan vertel u kliënt nie vir u die waarheid nie.
If that is your instruction, then your client is not telling you the truth. Ukuma kungaba ke lokho uthi ke lona ommele ukutshela lokho ke ukuthi wayengamelwe ngaleli langa kusho ukuthi akakutsheli iqiniso.
All right.